That's the feature apparently.
All right, good morning, everyone. The meeting of the Rhode Island Ethics Commission for Tuesday, June 4th will come to order. The first order of business is a pleasure to issue the oath of office to our newest commission member, Scott Rabideau. So I'll ask you to stand.
Well, nice to meet you all.
Nice to see you. Okay, I'm going to ask you to just repeat after me.
Absolutely.
Raise your right hand, please. You repeat after me. I.
Scott Rabideau,
Having been duly appointed by His Honor Governor Daniel J. McKee,
having been duly appointed by His Honor Governor Daniel McKee,
swear to uphold the duties and responsibilities of Commissioner of the Rhode Island Ethics Commission
swear to uphold the duties and responsibilities of Commissioner of the Rhode Island Ethics Commission
as enumerated in the state constitution, the laws and regulation of the state and of this commission,
as enumerated in the state constitution, the laws and regulations of this state and of this commission,
and further to abide
and further to abide
by my own conscience, independence, and integrity
by my own conscience, independence, and integrity
in fulfilling these duties.
in fulfilling these duties. So help me God.
Thank you very much. Congratulations. So welcome, you are our 8th commissioner. Do you want to just say a little bit about yourself?
Oh, sure. I am a freshwater and a coastal wetland biologist. Kind of an odd choice, I guess, for an ethics commission member, but I have been doing that since I graduated college, which was the University of Rhode Island. I own a small consulting firm that specializes in freshwater wetland delineations, coastal wetland delineations, and wildlife habitat assessments. We provide information that is necessary for regulatory permitting in the state of Rhode Island for both the Department of Environmental Management and the Coastal Resources Management Council. I am a lifelong Rhode Islander. I was born and raised and reside in the town of Burrillville, so I'm also from a different part of the state. And as you know, I'm sure you all know, I did have the honor of representing Burrillville in the General Assembly for 4 terms from 1995 to 2002. So I do have a bit of a political background there as well. So I look forward to working with everybody.
Great, well, thank you and welcome. Okay, now onward. Is there assignment? First item, or the second item, is a motion to approve the minutes of the open session held on April 30th, 2024. Is there a motion? Or second? Second. Moved by Commissioner Jones, seconded by Commissioner Susie. Roll call vote. Commissioner Jones?
Aye.
Commissioner Strauss?
Aye.
Commissioner Rabideau?
I was not here. So
Abstain.
Abstain.
Commissioner Centarini?
Aye.
Commissioner Susie?
Aye.
Commissioner Peterson?
Aye.
And the chair votes aye. Great, thank you. The next item is director's report.
Good morning and welcome, Commissioner Rapp. So we have a pretty full agenda here today, and I'm not gonna spend a long time on the director's report. I know you want to get through everything. I will just note that we're live streaming and we're recording the open session. All of that will be available on our website after the meeting. Our meeting materials for those people who are joining the live stream they are also available on the website. And we'll end the live stream as we go into executive session. We have a few items in executive session today, so it could last up to an hour. The live stream will stop during that, and then we'll come back into open session. At that point, the chair will report out anything that happened in executive session, and we'll also put a written notice of anything that happened in executive session on our website after. Regarding complaints and investigations, we have 7 total complaints pending, including one that's being initially determined today. So seven total pending complaints. With advisory opinions, we have 7 advisory opinions pending right now, including 5 on today's agenda. APRA requests, we had quite a few since the last meeting. We had 13 APRA requests come in. 12 of those 13 we were able to satisfy within 1 business day, which is the standard we hold ourselves to. The one that we couldn't was just a little more complicated. We had to have some communication with the person requesting it to clarify. 9 of these related to complaints, 3 were related to financial disclosure statements, and 1, just no records existed. It's a request that we just don't have here at the Ethics Commission. Briefly on financial disclosure, just regarding the current filing year, which is 2023, we've got almost 4,000 of these in now out of about 4,200 that will be required. We're up to 95%, which again is a percentage point or so ahead of where we normally are. So we're ahead of the game right now. We have about 218 non-filers as of today, and we're still working hard to reach those people and eliminate them as non-filers. With the, briefly, I just wanted to talk about, on a legislative update, there are no bills that I'm expecting that impact the Code of Ethics or the Ethics Commission that are going to get past this legislative session. I will note that I did do some Senate training this year, about a week ago. I trained the House and the Senate separately. And in both, I note that a question came up as to, is the Ethics Commission ever going to raise the $25 gift limit? That you put in back in, I think around 2004, 2005. Is it time to think about raising it up to some other number? My answer was that I thought the $25 limit was working pretty well. I was not inclined to advocate for an increase, but if anyone wanted to write to the commission and advocate for the commission to take up a hearing or to start considering raising that limit, I encourage them to do so. So I'll let you know if we receive any.
Could lead to lowering it too, right?
So but when I get asked these questions, I always say, I will definitely let the commission know that it was raised. And so you're now on notice.
We're on notice.
Then I'll just note that our next meeting is on June 25th, and then we have a nice kind of 4-week summer break until the meeting after that, which is the last week of July. So June 25th is the next meeting, and then the one after that will be July 23rd. That's all I have.
One question, have we, in the time I've been here, this hasn't happened before, have we ever faced a need to have a special meeting because it's something that came in that required more immediate reaction or response?
We have had special meetings outside of the tentative annual schedule that we publish. It doesn't happen very often. But yes, it's happened.
Any other questions? Okay, we'll move to advisory opinions, and we'll invite our first signing, Kelly Morris Salvatore. Come up. Good morning.
Good morning.
Good morning, Ms. Radisha.
Good morning, everyone. The draft for this petitioner can be found at tab A in your binders. Welcome, Attorney Salvatore. Petitioner is the solicitor for the town of Cumberland. She was appointed by the mayor with approval by the town council. Her duties include providing advice and representation to the planning board, the mayor, and the town council. There is currently pending before the planning board an application for a mill conversion to a mixed-use development. Negotiations for a tax stabilization agreement for the same project are also currently pending before the mayor, and any agreement reached will require approval by the town council. In her private capacity, the petitioner is a non-equity contract partner with Darrow Everett, a law firm in Providence. She is compensated for her work at the firm in the form of a salary plus commission on any matters that she originates for the firm. The owner of the property associated with the project in Cumberland has asked one of the petitioner's colleagues at the law firm to replace the owner's current attorney and to represent him in the matters now pending before the planning board, the mayor, and the town council. Like the petitioner, her colleague is a non-equity contract partner for the firm, and too is compensated in the form of a salary plus commission on the work that he brings into the firm. The petitioner seeks an advisory opinion regarding whether, following her recusal from participation in her role as solicitor on all matters relating to this project, the Code of Ethics would permit her colleague to represent the property owner before the planning board, the mayor, and the town council. In the event of the petitioner's recusal, the town's assistant solicitor would instead provide advice to these agencies on all matters relating to this project. Now, the assistant solicitor works for a different law firm than the solicitor and was also appointed by the mayor with the town council's approval. The petitioner had no role in the selection of the assistant solicitor, nor does she supervise that individual. Under section 36-14(5)(a) of the code, the petitioner may not take part in an official matter in which she has a substantial conflict of interest. As explained in section 36-14(7)(a), a substantial conflict of interest would occur if the petitioner has reason to believe or expect that she, a member of her family, her business associate, or her private employer would be directly financially impacted as a result of her participation. Petitioner's colleague is her business associate. She must recuse from taking part in an official matter when it is reasonably foreseeable, right? By reasonably foreseeable, I mean that it's more than conceivable and less than certain to occur, that her business associate will be directly financially impacted by reason of her official participation. Importantly, the Ethics Commission has determined that advice by a solicitor to a municipal agency does constitute official activity. 3 prior advisory opinions are cited in the last paragraph on page 2 in support of this. Under regulation 1.2.1, the petitioner must also recuse when her business associate appears before her municipal agency. In this case, the planning board, the mayor, and the town council. The petitioner's awareness of that responsibility to recuse is acknowledged, as is her preparedness to do so relative to all matters involving the project if her colleague is to assume representation of the property owner. Because the petitioner is not an equity partner in the law firm and does not share in the firm's general revenue, she does not stand to be personally, financially impacted by her colleague's representation of the property owner before these town agencies in Cumberland. Accordingly, based on the facts as represented, the applicable provisions of the Code of Ethics and prior advisory opinions issued, it is the opinion of staff that following the petitioner's recusal in her role as solicitor on all matters relating to the project, the Code of Ethics would not prohibit the other attorney from the law firm by which she is privately employed from representing the owner of the subject property or the planning board, the mayor, and/or the town council. I'm happy to answer any questions or to defer to Ms. Salvatore as appropriate.
Thank you. Thank you. Ms. Salvatore, you've heard the staff's recommendation. Do you have any comments or questions?
No, and I've spoken with Ms. Radicis about this matter, so I think I've given her all of the information that she required.
Any questions from the commission? My only question was, the question itself was whether or not the other attorney could come and take this client. And it seemed to me the question was really more about what she should do if that were to happen.
Exactly. He's not subject to the Code of Ethics.
Right, but yet the question was in that form. It just, is there a reason for that? And not more about her own?
Well, I defer to Ms. Salvatore if I'm not saying this correctly. When we spoke on the phone, it seemed somewhat of a layup. And I said that I don't usually say how I think things are going to come out, but unless something really drastically changes, this is how it's going to come out. And I think the question was phrased to perhaps satisfy the people who maybe were suggesting that there was an issue.
No, I actually thought I should come myself
Oh,
and
absolutely.
in consultation with you. The way the question is worded, clearly it's about my recusal,
Right,
but it involves my partner.
right.
So
Just seemed funny to me that we're saying, yes, your partner can come. when
If she
really,
refuses. I think
Right.
because the
Yeah.
recusal is part of the facts.
yeah,
It like the question
Right.
could be what hasn't happened in order for her, but because I'm carrying into the question presented, there is going to be a recusal.
based on those facts.
Based on those facts, that's where the question came, but you're absolutely right, we can't keep her locked
Right.
up from doing
Right.
anything.
right. Okay, great. All right, is there a motion to accept the staff's recommendation?
I'm so moved.
Okay, I'll move by Commissioner Centarini and seconded by Commissioner Jones. Roll call vote, Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Rabideau,
Aye.
Commissioner Center.
Aye.
Commissioner Susie. Aye. Commissioner Peterson.
Aye.
And the chair votes aye. Great, thank you
Thank
very
you.
much.
Thanks. Thank you. Yes, thanks.
The next sign-in is Paul Jordan.
Morning.
Good morning. Mr. Jordan. Good morning.
Good morning, Commissioners. This advisory opinion is.
Madam Chair, before we start, if I may, I have never met Mr. Jordan personally.
Oh.
But in his capacity as a data analyst at the Department of Environmental Management, myself and my firm interact with him on a regular basis, so I think it's best if I recuse from this matter.
Okay, great. So you can step out. Great, thank you. And can I ask you to introduce yourself?
Oh, yeah, sorry, Attorney Johan Donald, I'm legal counsel for the department.
Great, thank you.
Good morning. This advisory opinion is on the top D in the binders. Mr. Paul Jordan is employed by the Rhode Island DEM. And as part of his public duties, he's also the assistant state liaison to the National Park Services Land and Water Conservation Fund. In that capacity, he helps public officials or assists them, municipal officials in maintaining compliance with the federal grant requirements with regards to the fund. The town of South Kingstown is planning on building a new high school. They would like to build a new high school on the same property where the existing high school is. Mr. Jordan has provided a map that is included in your binders. I have indicated the high school property is comprised of two lots. One is the recreational lot, which houses the recreational field, and the other one houses the high school building, or I'll call it school lot. The town proposes that the new high school building be constructed on the current recreational lot. Once that building is constructed, they're planning on demolishing the old high school building and then creating the recreational field instead of it. Because the current recreational lot was developed with land and water conservation fund money, federal rules require that its use remain the same in perpetuity. The town can change its use, however, they have to apply for a conversion of it. The applications for conversion are submitted to the DEM. They're reviewed by Mr. Jordan. After his review, those applications are reviewed by his superior, who is the state liaison officer. And after which those applications will be forwarded to the National Park Services for approval. The petitioner informs that some town residents have expressed concern that he should not be participating in the review of the application just because he is a resident of the same town. The petitioner states that he is not on a border to the school property. His home is located approximately half a mile away from that property. He does not see the school property from his home. He did not receive an abutters notice for the project, and does not have any family members or business associates who abut the school property, and also doesn't have any school-age children who attend the school system. He represents that a review of the conservation application would not have a financial impact upon him, although the building of the school and the school project would increase taxes proportionally for all the residents in the town. Given the set of facts, Mr. Jordan seeks guidance from the Ethics Commission regarding whether the code prohibits him from reviewing the town's conservation application. In advisory opinions involving real property, the Ethics Commission has consistently applied a rebuttable presumption that a property owner will be financially impacted by an official action concerning a bank property. The commission also applied the opposite presumption that there will be no financial impact if, if the official action involves property that it's in close proximity but not abutting the petitioner or public officials' property. Here, based on the petitioner's representations, the prior advisory opinions issued and the relevant provisions of the Code of Ethics, it is the opinion of the staff that Mr. Jordan may participate in the review of the applications submitted by the town. I'm happy to answer any questions you may have at this time.
Thank you. So you've heard the staff's recommendation. Do you have any comments or questions?
I do not.
Okay, any comments or questions? I'm curious, have you ever reviewed other things from South Kingston?
Yes.
Is there a motion to accept the staff's recommendation?
I'll move.
Second.
Moved by Commissioner Peterson, seconded by Commissioner Susie. Roll call vote, Commissioner Jones,
Aye.
Commissioner Strauss.
Aye.
Commissioner Centerini.
Aye.
Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
And the chair votes aye. Great, thank you.
Thank you.
Activity, huh?
The next item is Ed Mello. Morning.
This advisory opinion is in the top C of the binders. May I proceed?
Yes.
Mr. Mello is the Jamestown Town Administrator. He's been serving in that position since July of 2023. Him and his spouse own two homes in the town. One they currently reside in, and another one that they currently use as a rental unit year-round. Sometime during the next 4 years, they plan to move in the current rental property and utilize it as their primary residence. And in preparation of that move, they would like to construct a single car garage on that property. In order to do so, however, Mr. Mello needs to receive a building permit, and the application for it goes to the town planner and then to the zoning/building official. Mr. Mello represents that he has supervisory and appointing authority over those two officials. Both the town planner and the zoning building official are considered town employees and do not have a set term of employment. He represents that he did not participate in those officials' hiring process because they were hired prior to his appointment as a town administrator. Given this set of facts, he seeks guidance regarding whether he qualifies for a hardship exception to appear and seek that building permit from those two officials. The petitioner's proposed conduct falls squarely within section 5E's prohibition. The Ethics Commission now would have to consider whether the totality of the circumstances represented by the petitioner justify a finding of hardship. The Ethics Commission, when review questions of hardship related to real property, the commission reviews several factors. One is whether the subject property involved the official's principal residence or principal place of business, whether the official's interest in the property is pre-existent as public office or was recently acquired, whether the relief sought involves a new commercial venture or an existing business, and whether the matter involves a substantial economic impact. None of those factors is determinative when deciding on hardship. I have listed several examples of past advisory opinions on page 3 of the draft. Based on the petitioner's representations, the applicable provisions of the code, and the prior advisory opinions issued, it is the opinion of the staff that the totality of the circumstances here justify the application of a hardship. Accordingly, the petitioner may represent himself either personally or through a representative before the town planner and the zoning/building official relative to the proposed construction of the garage. However, in order to avoid even the appearance of impropriety, the petitioner must recuse from discussions and decision-making relative to the town planners and the zoning building officials' job performance, rotation, or reappointment until after the application is approved, all the inspections are done, certificates, if necessary, are issued, and any appeals of it have been completed. Additionally, the petitioner shall, prior to the appearance before those two public officials, prior to the application, must inform those public officials of the receipt of the advisory opinion and that he will follow all the requirements within it. I'm happy to answer any questions you may have.
You've heard the staff's analysis and recommendations. Do you have any comments or questions?
No, ma'am, no questions.
Any question?
I guess I'll ask the question, which is if he wasn't represented and he was gonna move there, would he fit the qualifications? Would the totality of circumstances be appropriate from your point of view?
It may not, it may not, the property was acquired prior to his appointment to the town council, so we kind of have to weigh them under each circumstance. The property was acquired prior to his appointment. Now it's being rented out. It's not his primary residence. It's not his, or I'll assume it's not his primary or existing business. It could be considered an existing business also. And so I'm not sure under those circumstances what our opinion on it.
I'm sorry.
That's all I'm saying, and again, I'm not suggesting that we shouldn't, so that's based on, the opinion is based on Mr. Mello's representation of what he intends to use the property for.
Correct, correct. He intends to, even though right now it's commercial or it's used for rental property, he intends to move there, and that's why he wants to construct the garage. So based on those facts, and it was acquired prior to his appointment, he also represented that process is more administrative because he's not asking for any variances. So based on the totality of those circumstances, staff's recommendation is that the hardship would be applied, yeah. But if it was a different facts, it could change.
The Commissioner Jones follow-up question, acknowledging as it's stated in the information provided, the gentleman apparently expressed an intention to move there, and you gotta get the property ready.
Yeah,
So,
and it's, I mean, we always rely on what,
No,
and you're moving to a great neighborhood.
Agreed.
He's my neighbor around the corner when he moves in. You'll see me walking my dog without leash.
Getting a nice neighbor a source of recusal.
No, I just need to have some help with reconciling this from my memory. Seems to me a couple of years ago, we had an advisory opinion where we had a pretty serious discussion about in order to avoid even the appearance of impropriety, and we had that, as I recall, removed from the advisory opinion. That phrase, we said we can't.
I don't think so. I think, I know that you raised something. I don't know that we would have.
I think under 5E, the commission can impose any other requirements in order to grant a hardship exception. And I believe the prior commissioners have imposed that requirement to recuse, so the subordinate doesn't feel the pressure to vote one way or the other.
Yeah, and I don't disagree with it. I was just trying
Yeah.
to remember what had happened before.
Yeah.
I don't,
And
I recall having the discussion.
Yeah.
I don't remember what we
Yeah.
did. I don't think we get out.
It was, I think that was about future action, like not the instant question, but it was like it was
That's right,
other
you're
things,
exactly
and
right.
so we were like, I think we talked about maybe like not doing that, but this is different.
Okay.
What the statute says is that in cases of hardship, the Ethics Commission may permit such representation on application by the official, provided that he or she shall first, among other things, follow any other recommendations the Ethics Commission may make to avoid any appearance of impropriety in the matter.
That makes sense.
I guess my only question on that, is we don't want this to hold up their performance reviews, right? If for some reason a performance review is required for, salary compensation adjustments, I wouldn't want this to hold up that.
So I can defer to Mr. Mello, he may be more familiar with the process, but those public officials are nominated by charter, nominated by the town administrator and with the consent of the town council. So I'm not sure if maybe the town council could review their performance, if that.
Yeah,
is
I
an
can offer
option.
some clarification about performance reviews,
Mhm.
particularly as it relates to any salary increases. So, performance reviews, by staff are not associated to salary increases
Okay.
of all administrative staff. Administrative staff is a budget process by
Okay.
which the council, adopts a budget, which includes any salary increases for staff members. So it's irrelevant of any performance review that may happen.
That makes sense.
I guess I have a question, Madam Chair. if I could.
Yes,
So Rhode Island being what it is right now, what do you anticipate as a timeline for construction of this garage? Since you're going to have to not be able to discipline or deal with the building and zoning official over that period of time.
I don't have a guess on that, so the permit that I'm asking for is simply the permit to allow the construction of the foundation. And that is a place where we will pause. There will be a separate permit that would have to be applied for the actual construction of the garage at some point down the road.
So we are only issuing this advisory opinion for the construction of the foundation only, not the garage itself.
I don't know how the building official will look at that. That is my intent, in terms of timing. So I don't know, how the building official will review that. It's kind of the chicken and the egg about how I start the application.
But I'm looking up for you more than anything, because if it's, you're only building the foundation and you don't build the garage for another 2 years, this advisory opinion could be binding on you for that 2-year timeframe. And is that okay with you in terms of your responsibilities as administrator for the town?
Yes.
Director of Public Works, to whom the building official and zoning official report generally.
A different division. They are their own division. The building division is one division. Planning is a separate division.
Who heads up the zoning official, for example?
There's one official there is one official that is the building and zoning official, a department of one.
One. That's what I was curious about. Okay.
I would also suggest that if this opinion issues and going forward, the petitioner finds that this condition is causing an issue,
yeah,
and he's welcome to reach back out to
Yeah.
the staff here. We can talk about whether he could seek a little clarification of another advisory opinion to adjust the condition under exigencies or
Yeah.
necessity. So
is there a motion to accept the staff's recommendation?
So moved.
Is there a second?
Second.
Moved by Commissioner Jones, seconded by Commissioner Senarini. Roll call vote, Commissioner Jones.
Aye.
Commissioner Strauss.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Senarini.
Aye.
Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
And the chair votes aye. Thank you.
Great. Thank you very much. Thank you.
Thank you. And our last sign-in is Val Lawson. And I can't read the other name.
Hello again. The draft for this petitioner is at tab B in your binders.
And it's Val Lawson and.
Carly Iafredi.
Thank you.
Welcome to you both. Senator Lawson represents District 14 in East Providence. She was employed by the East Providence School Department for 32 years, but left that position on December 31st of 2022 to become the president of the National Education Association of Rhode Island, or NERI. After that organization's former president vacated the position, and this is a full-time position. Although Senator Lawson is no longer employed as a teacher, she is not formally retired. She is currently in deferred status relative to her participation in the state's pension system. A bit more about NERI. It is the Rhode Island affiliate of the National Education Association. It is a private organization. the purpose of which is to provide collective bargaining representation, grievance and arbitration representation, professional development opportunities, and other benefits to its members. NERI has somewhere between 11,000 and 12,000 members. They include public sector teachers, public and private sector education support professionals, public and private sector higher education faculty, graduate students and staff, and state and municipal employees and retirees. In addition to Senator Lawson, there are approximately 400 other NERI officers and leaders who are positioned to direct and affect the financial objectives of that organization. There are 5 bills identified and described in the draft for which a Senate vote is imminent. Given her prior and current employment and her membership in the pension system, Senator Lawson seeks advice from the Ethics Commission regarding whether she may vote on these bills. Senator Lawson is not seeking to participate in any discussions leading up to a vote, nor did she participate in the discussions when each bill was before a committee of which she was not a member. Under the Code of Ethics, a public official may not participate in any matter in which she has an interest, which is in substantial conflict with the proper discharge of her duties in the public interest. A substantial conflict of interest occurs if a public official has reason to believe or expect that she, a family member, a business associate, or a private employer will be directly financially impacted by reason of her official activity. The 5 bills at issue here are outlined on pages 2 and 3 of the draft. All but one will directly financially impact the petitioner. All 5 bills, if passed, will directly financially impact the other 400 or so officers and leaders from NERI, who are the senator's business associates. None of the 5 bills, if passed, will directly financially impact NERI itself, the senator's private employer. Section 3614(7)(b) of the code, referred to as the class exception, states that a public official will not have an interest which is in substantial conflict with the proper discharge of her public duties if any benefit or detriment accrues to the public official, any person within her family, her business associate, or any business by which she is employed as a member of a business, profession, occupation, or group, or of any significant and definable class of persons within the business, profession, occupation, or group, to no greater extent than any other similarly situated member of the business, profession, occupation, or group, or of the significant and definable class of persons within the business, profession, occupation, or group. When determining whether particular circumstances justify the application of the class exception, the Ethics Commission considers the totality of the circumstances. There are some important factors considered, which are the following: a description of the class, the size of the class, the function or official action being contemplated by the public official, and the nature and degree of foreseeable impact upon the class and its individual members as a result of that official action. The Ethics Commission has previously applied the class exception in a variety of circumstances involving proposed legislation. 4 such advisory opinions are cited on pages 4 and 5 of the draft. Here, the official action being contemplated by the petitioner is voting on each of the 5 bills discussed. The classes that would be impacted by the passage of one or more of these bills, and the classes to which Senator Lawson and/or her business associates belong, include the following. First, all active members within the pension system, which is estimated to be 40,000 people. Next, all members of the pension system who are in retirement status and/or their beneficiaries, which is estimated to be 28,000 people. And finally, all teachers and other state and municipal employees who will be eligible to retire on or after July 1st, 2024, which is estimated at 30,000 individuals. Based upon the facts as represented, the petitioner's vote on each of the 5 bills would impact herself in all but one case where she would not be impacted at all, and impact her business associates in all cases. to no greater extent than any other similarly situated member of that particular applicable class. Accordingly, it is the opinion of staff that the circumstances herein do justify the application of the class exception, and the petitioner is not prohibited by the code from participating in the Senate's floor votes on these 5 bills. However, in the event that any discussions that occur prior to the votes veer into amending any of those bills in ways that would impact the petitioner and or her business associates individually, or as a member of a much smaller class or subclass of any of the classes identified earlier, the petitioner must either recuse from participation in those discussions and or votes that follow, or seek additional guidance from the Ethics Commission. I'm happy to answer any questions or to defer to Senator Lawson or Attorney Iafrate as appropriate.
You've heard the staff's recommendations. Do you have any comments or questions?
I do not.
Any comments or questions from the commission? Okay. Yes.
If I might, I just wish to mention, I did initially have a reservation about participating in this since I am a retired state employee. However, I did consult with legal counsel and also the executive director, and I feel that I can fully participate.
Excellent, thank you.
That's correct.
Thank you.
Is there a motion to accept the staff's recommendation? Is there a second?
Second?
Okay, moved by Commissioner Jones, seconded by Commissioner Peterson. Roll call vote. Commissioner Jones?
Aye.
Commissioner Strauss?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Centerini?
Aye.
Commissioner Susie?
Aye.
Commissioner Peterson?
Aye.
And the chair votes aye. Great, thank you very much.
Thank you so much.
How many members? I do.
Quite
Quite all of them, right? Yeah, right.
Okay, the next advisory opinion is Christian LaChapelle Miller.
Thank you. Mr. LaChapelle Miller, wasn't present today. I believe he has another meeting, so that was previously scheduled, so we could have attended. But he, asked me to proceed in his absence.
Thank you.
He is the Chief Implementation Aide to the Director of the DCYF. He's been serving in that position since August of 2023. He provides support to the Director relative to the implementation and administration of department special projects and programs. I have listed a sample of his duties on page 1 of the draft. In his private capacity, he is the Chief Executive Officer and President of Generous Heart. This is a private non-profit organization founded in 2021. Generous Heart was organized to promote sustainable, independent living and improved economic outcome for young adults who are previously involved in foster care. They do that by providing a direct financial relief to those individuals. Generous Heart is governed by a board of directors and receives philanthropic, private, and corporate sponsorship funds. Generous Heart does not receive any federal or state funding and does not contract with the DCYF. Prior to his employment with the DCYF, Mr. LaChapelle Miller entered into a memorandum of understanding on behalf of Generous Heart with Communities for People. I will refer to them as C4P. C4P is a private nonprofit organization that provides foster care services in Rhode Island for children and adolescents in the custody of the DCYF. Pursuant to the MOU, C4P will provide back-end administration to and office support to Generous Heart. That would include providing pre-office space to Generous Heart, providing any access to C4P's administrative support staff would help. The example was helping them with filling out applications or following processes that they need to follow, file storage space and technologies such as printers and fax machines. As a precautionary measure, given the petitioner's subsequent employment with the DCYF and pending the issuance of advisory opinion, will assist the petitioner with avoiding any conflicts of interest under the code. The MOU was paused. It was not implemented. Unlike Generous Heart, C4P is a vendor with the DCYF and receives both state and federal funding. C4P provides services to our youth while they are in state foster care, whereas the petitioner represented that Generous Heart provides services to the same youth once they leave foster care. The petitioner represents that Generous Heart does not contract with C4P for provisions of services related to its contract with DCYF. And the petitioner represents that as chief implementation aide to the director, he does not oversee C4P, and he does not participate in any discussions and decision-making relative to C4P's budget or the renewal of their contract. The petitioner may be asked to attend meetings in place of the director. And during those meetings, representative of C4P may be present. However, he explained that the extent of his participation may be just to sit, observe, and bring back information to the director. Nonetheless, he represented that he would recuse from participation in such meetings where representatives of C4P are present. He's there to represent the director's office in the matter impacts only C4P. The petitioner's initial advisory opinion requests sought advice whether C4P and Generous Heart can proceed with the implementation of the MOU. However, those two entities are private and they don't fall under the jurisdiction of the Ethics Commission. Therefore, his question changed and he's now seeks guidance from the Ethics Commission regarding whether the Code of Ethics prohibits his participation in Generous Heart's implementation of the MOU between Generous Heart and C4P. The Ethics Commission has consistently opined that public officials and employees are not inherently prohibited from holding private positions that are in addition to their primary public employment or position, subject, however, to certain restrictions and provided that their private position would neither impair their independence of judgment nor create an interest in substantial conflict with their public duties. Here, it is the opinion of the staff that there is no indication that the petitioner's participation in Generous Heart implementation of the MOU between Generous Heart and C4P would either impair his independence of judgment or create an interest in substantial conflict with the proper discharge of his duties with the DCYF. Therefore, the petitioner is not prohibited by the Code of Ethics from participating in the implementation of the MOU, provided, however, that all of that work on behalf of Generous Heart is performed on his own time and without the use of public resources or confidential information obtained as part of his public duties. As a result of his simultaneous public and private service, the petitioner is required to remain vigilant and avoid and manage any conflicts of interest that may arise. Here, the petitioner is a business associate of Generous Heart because of his position as CEO and president. Generous Heart and C4P are business associates. However, the petitioner is not a business associate of C4P, given that based on his representations, there is no indication of an independent financial nexus between the petitioner and C4P. Therefore, the petitioner will not run afoul of sections 36-14, 5A and D, and regulation 1.2.1 while performing his public duties relative to C4P. Nonetheless, the petitioner may run afoul of section 5B of the code as it pertains to his independence of judgment while he performed his duties relative to C4P, given that the petitioner's position with Generous Heart the MOU between Generous Heart and C4P, and he's anticipating involvement with the implementation of it. Accordingly, it is the opinion of the staff that the petitioner shall recuse from participation in those DCYF meetings, whereas described by him, he may be asked to sit as a representative of the director's office. Representatives of C4P are present, and or the subject matter of the meeting involves and or financially impacts C4P. This advisory opinion, however, cannot anticipate every possible situation in which a conflict of interest may arise. Therefore, the petitioner is advised to seek further guidance from the commission if needed, or if the facts change. The petitioner is reminded that he may not use his public employment or confidential information received through his public employment to obtain financial gain to Generous Heart or any of his other officers. The petitioner is required to remain vigilant about potential conflicts of interest and either accuse or seek further guidance from the commission. And also, if any of his duties change, either in his private capacity or his public capacity, he may also seek further guidance from the commission. Thank you. I'm happy to answer any questions.
Great, thank you. Any questions, comments? No? Any? Yeah. Is there a motion to accept the staff's recommendation?
So move.
Okay, moved by Commissioner Centerini, seconded by Commissioner Jones. Roll call vote. Commissioner Jones?
Aye.
Commissioner Strauss?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Centerini?
Aye.
Commissioner Susie?
Aye.
Commissioner Peterson?
Aye.
And the chair votes aye. Thank you.
Thank you.
Okay, next item is a motion to go into executive session. To wit, to take up a motion to approve the minutes of the executive session held on April 30, 2024, pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4, to consider in re Michelle Vaca, complaint number 2024-3, pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4, to take up in re Michael Calasante, complaint number 2023-10, pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4, to consider in re Olivia D. Francesco, complaint number 2024-7, pursuant to Rhode Island General Laws 42, 46, 5A, 2, and 4, to discuss the annual review of legal counsel's contract pursuant to Rhode Island General Laws 42, 46, 5A, 1, and then to consider a motion to return to open session. Is there a motion to go into executive session?
So
Is there a second?
Second.
Roll call vote. Commissioner Jones?
Aye.
Commissioner Strauss?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Centerini?
Aye.
Commissioner Peterson?
aye.
And the chair votes aye.
Aye.
Oh, I'm sorry, Commissioner Susie. I marked you off. Isn't that funny?